Hello, my name is Rebecca Harrison and I run SEN Home Ed. I am also a SEN parent carer and I want to make life a lot more easier for us fellow SEN parents and carers when navigating the murky waters of trying to get what our children are entitled to. So today I'm just doing a quick video on the difference between lasting power of attorneys and deputyships via the Court of Protection. What's the difference? When do you apply? And what does it involve? I get asked this a lot, and it was specifically brought up at a Christmas party which I was a part of for SEND parents and carers in my area, and I had a couple of SEND parents saying they were confused about what a lasting power of attorney is. How is it different from a deputyship? What's an enduring power of attorney? So as I said, I'm just going to do a quick video just to go over the basics. So I'm from the UK, so I am talking about the UK's legal system here. So in the UK, parents and carers can begin the process of securing what's called a lasting power of attorney. The acronym is LPA, or applying for a deputyship as their child approaches the age of 18. Why is the age 18 so important? Well, it's so important because this transition period is crucial because in the eyes of the law, parental authority over medical, financial or welfare decisions ends when the child becomes an adult. So if your child has needs where they need support of a parent or carer, you will not have the authority to do that. Health professionals will ask specifically to talk to your child rather than you. They will not share information with you. They will share it with your child, whether your child has the capacity to understand that information or not. So, before the age of 18, parents automatically have the right to make decisions on behalf of their child, unless limited by specific legal restrictions. However, from the age of 18, parents lose automatic decision-making rights to continue supporting their child in the way they've previously done. Therefore, in some circumstances, the parent or carer needs to apply for a lasting power of attorney or a deputyship. Just so you're not confused, a lot of people ask me about enduring power of attorneys. They went out around 2007-2008 time, so no one can apply freshly for them anymore. They are gone. Some people still have them or applied for them all those years ago, but now if you are going to go for anything, what's available is either a lasting power of attorney or a deputyship. So what happens here? So a lasting power of attorney can only be arranged if the child has mental capacity to understand and consent to giving their parent or carer the power of attorney over their financial affairs and or, because you can have either or both together, or health matters or health matters. So it's really suitable for children who can independently make and communicate decisions but want someone they trust to assist with financial or health related matters to do with themselves. In comparison, a deputyship via the Court of Protection is for a child that lacks mental capacity to make decisions independently. Normally these children are non-verbal, have, not always non-verbal, but a lot of the time they're non-verbal. They don't have the understanding, they might be incapacitated. You're the best judge of what your child's mental capacity is. So if your child lacks the mental capacity to make decisions independently, you can apply for a deputyship via the Court of Protection in order to deal with their financial or health affairs, or both financial and health affairs. So it's really important when your child's getting to that age of 18 to prepare for the transition from childhood to adulthood. Parents or carers should start exploring these options regarding lasting power of attorneys and deputyships before the child turns 18, as both processes can take a lot of time to complete. So it is really advisable at this stage to assess the child's capacity for decision making with input from medical professionals if necessary, and decide whether a lasting power of attorney which is if the child has a mental cognition and can consent, or deputyship if the child lacks mental capacity, is most appropriate. Once you've decided whether a lasting power of attorney is needed or deputyship, then you can apply for the lasting power of attorney forms and guidance from the Office of the Public Guardian, or for a deputyship via the Court of Protection. If you are on certain benefits, such as universal credit, you may be able to get this done for free, but obviously you need to look into this further for yourself. Please let me know if this has been any help to you, and whether you would like the booklet to accompany this talk to give you further information. Thank you very much, and goodbye.